Abortion already is dominating the Supreme Court's new term, months before the justices will decide whether to reverse decisions reaching back nearly 50 years. Not only is there Mississippi's call to overrule Roe v. Wade, but the court also soon will be asked again to weigh in on the Texas law banning abortion at roughly 6 weeks. The justices won't be writing on a blank slate as they consider the future of abortion rights in the U.S. They have had a lot to say about abortion over the years, in opinions, votes, Senate confirmation testimony, and elsewhere. Just one, Clarence Thomas, has openly called for overruling Roe and Planned Parenthood v. Casey, the two cases that established and reaffirmed a woman's right to an abortion. Here is a sampling of their comments. Roberts voted to uphold restrictions in two major abortion cases, in the majority in 2007 to uphold a ban on a method of abortion opponents call partial birth abortion, and in dissent in 2016, when the court struck down Texas restrictions on abortion clinics in a case called Whole Woman's Health. But when a virtually identical law from Louisiana came before the court in 2020, Roberts voted against it and wrote the opinion controlling the outcome of the case and striking down the Louisiana law. The Chief Justice said he continues to believe that the 2016 case was wrongly decided, but that the question was whether to adhere to it in deciding the present case.
Roberts' views on when to break with court precedent could determine how far he is willing to go in the Mississippi case. At his 2005 confirmation hearing, he said overturning precedent is a jolt to the legal system, which depends in part on stability and even-handedness. Thinking that an earlier case was wrongly decided is not enough, he said. Overturning a case requires looking at these other factors, like settled expectations, like the legitimacy of the court, like whether a particular precedent is workable or not, whether precedent has been eroded by subsequent developments, Roberts said then. In the same hearing, Roberts was asked to explain his presence on a legal brief filed by the George H.W. Bush administration that said Roe's conclusion that there is a right to abortion has no support in the text, structure, or history of the Constitution. Roberts responded that the brief reflected the administration's views. Thomas voted to overturn Roe in 1992, in his first term on the court, when he was a dissenter in Planned Parenthood v. Casey. He has repeatedly called for Roe and Casey to be overturned since. In 2000, he wrote in dissent when the court struck down Nebraska's ban on partial birth abortion. Recounting the court's decision in Roe, he wrote, in 1973, this court struck down an act of the Texas legislature that had been in effect since 1857, thereby rendering unconstitutional abortion statutes in dozens of states. As some of my colleagues on the court, past and present, ably demonstrated, that decision was grievously wrong. Abortion is a unique act, in which a woman's exercise of control over her own body ends, depending on one's view, human life or potential human life. Nothing in our federal constitution deprives the people of this country of the right to determine whether the consequences of abortion to the fetus and to society outweigh the burden of an unwanted pregnancy on the mother. Although a state may permit abortion, nothing in the Constitution dictates that a state must do so. Braille has been the lead author of two court majorities in defense of abortion rights, in 2000 and 2016. He has never voted to sustain an abortion restriction, but he has acknowledged the controversy over abortion. Millions of Americans believe that an abortion is akin to causing the death of an innocent child, while millions of others fear that a law that forbids abortion would condemn many American women to lives that lack dignity. He wrote in the Nebraska case 21 years ago, calling those views virtually irreconcilable. Still, Braille wrote, because the Constitution guarantees fundamental individual liberty and has to govern even when there are strong divisions in the country, this court, in the course of a generation, has determined and then redetermined that the Constitution offers basic protection to the woman's right to choose. Alito has a long track record of votes and writings opposing abortion rights. As a jurist and, earlier, a government lawyer, Alito has voted to uphold every abortion law the court has considered since his 2006 confirmation, joining a majority to uphold the federal partial birth abortion law and dissenting in the 2016 and 2020 cases. As a federal appeals court judge, he voted to uphold a series of Pennsylvania abortion restrictions, including requiring a woman to notify her spouse before obtaining an abortion. The Supreme Court ultimately struck down the notification rule in Casey and reaffirmed the abortion right in 1992 by a 5-4 vote. Working for the Reagan administration in 1985, Alito wrote in a memo that the government should say publicly in a pending abortion case that we disagree with Roe v. Wade. Around the same time, applying for promotion, Alito noted he was particularly proud of his work arguing that the Constitution does not protect a right to an abortion. Sotomayor joined the court in 2009 with virtually no record on abortion issues, but has voted repeatedly in favor of abortion rights since then. Recently, when the court allowed Texas' restrictive abortion law to take effect, Sotomayor accused her colleagues of burying their heads in the sand. She was in the majority in the Texas and Louisiana abortion clinic cases. Sotomayor's displeasure with the court's recent Texas ruling was evident at a recent virtual appearance she made. "I can't change Texas law, but you can," she said. Kagan also has repeatedly voted in favor of abortion rights in more than 11 years as a justice. She is also arguably the most consistent voice on the court, arguing for the importance of adhering to precedents and can be expected to try to persuade her colleagues not to jettison constitutional protections for abortion. Kagan was in the majority when the court struck down the Texas and Louisiana restrictions on abortion clinics. More recently, Kagan called Texas' new abortion law patently unconstitutional and a clear, and indeed undisputed, conflict with Roe and Casey. Kagan had already grappled with the issue of abortion before becoming a justice. While working in the Clinton White House, she was the co-author of a memo that urged the president for political reasons to support a late-term abortion ban proposed by Republicans in Congress, so long as it contained an exception for the health of the woman. Ultimately, President George W. Bush signed a similar late-term abortion ban without a health exception. The Supreme Court upheld it.
Thank you for watching. Please subscribe